The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. First of all, it's my understanding, is there a bunch of kids here from Audubon? Raise your hand if you're from Audubon. There they are. Thank you for participating in this public hearing. We appreciate having schools come here. We're going to go down the bench here in order of who was on the court when. I am the chief, and so I'll go first, and then to my right, and then to my left. That's how we go. That's in the order of how judges were appointed to the bench. We're going to tell you what high school we went to, and you're going to recognize mine, Harlan.
I'm Justice Apple, Dubuque Senior High.
Tom Waterman, Bettendorf High School.
I'm the oddball out. I went to Lexington High School in Lexington, Massachusetts. I'm an Iowan by choice.
Christopher McDonald, Des Moines Lincoln High School, home of the Rail Splitters.
I went to what was Greenfield High School when I graduated. Now it's called Nottoway Valley.
Hello, Fighting Wheelers. I'm Matt McDermott. I went to Kemper in Carroll.
Well, I'm going to say Harlan Cyclones. I have to now. Okay, thank you for joining us. Now, back to why we really are sitting here on, oh, you know what? Mr. Sloven, why don't you announce which high school you went to?
Valley High School.
Valley. And Ms. Reddy?
I am also an Iowan by choice, so I went to high school in Kansas, Field Kinley Memorial High School.
That's something we all have in common is high school. All right, first case is going to be State versus Davis by oral argument. The second case is State versus Kunjan, also oral argument. There will be two additional cases submitted today without oral argument. State of Iowa versus Hollis Bear and State of Iowa versus Peter Veal. Those two last cases are submitted now without oral argument. We will start with the case of Davis. When Davis is completed, we'll take a break between the two. The court will actually leave the bench for about 10 minutes. That's going to allow our staff to help set up an oral argument by video for the second one. So we will take a brief break between the two cases. State versus Davis. The resistor may begin, and I believe that's Ms. Reddy.
May it please the court. Mr. Sloven, I am Vidhya Reddy, and I am here on behalf of defendant appellant Ethan Davis. Mr. Davis appeals his murder conviction, seeking a new trial on a number of grounds. Today, I intend to focus primarily on the two jury instructional errors, unless this court has questions on the other issues. So,
address the standard of error when we have a standard review, when we have two competing instructions, assuming maybe both of them are acceptable, what would the standard of review be?
Sure. So that is an issue that the defendant is requesting clarification on from the court. As you know, the court is aware, in the 2016 Alcala decision, the court clarified the standard of review that applies to jury instruction claims. Prior to that, there had been statements in case law saying that instructional error in the submitted instruction is reviewed for errors at law, and that a refusal to submit an instruction that's requested is instead reviewed for abuse of discretion. So Alcala clarified that the law in Iowa is that if the requested instruction is a correct statement of the law, then it must be submitted by the district court, and the court.
That sentence, a correct statement of the law not covered by other instructions, and that's our fighting issue here, isn't it?
That's true. I think the question is how we understand that standard of whether it's covered in other instructions. So the state certainly takes the position that if the submitted instruction is legally adequate and covers, includes a minimally constitutionally sufficient instruction of reasonable doubt, then the concept of reasonable doubt is included, and the Court of Appeals, it kind of goes along with that and says that the alternative formulations of reasonable doubt, including both the firmly convinced standard that was submitted and the hesitate to act standard that was requested and previously approved, that they are basically cumulative, that it doesn't add anything. In terms of how that bears on the standard of review, defendant acknowledges that there are kind of two ways to understand whether it's covered, and one is, that it satisfies the Alcala rule of not being covered if the particular formulation is not included. That's a defendant's position. But even if this court agrees with the state's view that if the instruction that's submitted is minimally constitutionally adequate, that the failure to include one of the alternative formulations like hesitate to act doesn't satisfy that requirement of not being included, defendant would point the court to the general principle under Porter and other cases that where a defendant requests additional amplification, even if the submitted instruction is minimally adequate, the requested amplification must be included if it's timely requested, if it states a correct statement of the law, and if that amplification is not otherwise included.
Isn't Porter distinguishable in that in that case there were several specifications of negligence that weren't addressed at all, and so it was there to not give the jury the instructions requested to address those elements? So,
and admittedly, Porter is a very long decision and includes a number of different challenges, but what defendant would emphasize, and in particular the pin sites that are cited in the further review application in discussing that case, Porter ultimately concluded that the submitted specifications were adequate to cover all of the theories of negligence that the defendant had pled, and that so that there wasn't an issue with the failure to submit the additional specifications. However,
Substantively, why is the hesitate to act language better or superior than the instruction that was actually submitted?
Defendant's position is that there are multiple alternative formulations of reasonable doubt. And the court has not adopted or said that a single, one of those formulations is the best formulation or is the exclusive formulation that covers it. And so it's entirely reasonable that different entities, different courts, different...
Better if we were going to pick one or bless an instruction, substantively, why should we prefer that instruction versus the instruction that was given? And then how would you answer, for example, Justice Ginsburg's criticism of it, that it's actually a bad instruction?
Well, number one, I think based on existing case law, both in this jurisdiction and in the United States Supreme Court, the hesitate to act language has been approved as a correct instruction. Different entities have different have concerns on which ones might be better or worse, but as defendant has argued in the...
You tell us why you think the hesitate to act instruction is a better formulation. I understand it's constitutionally sufficient. A minority of jurisdictions have adopted it. Here we have two competing instructions. What is the substantive reason why this formulation is better than the instruction that was given?
What provides a greater understanding of what the concept of reasonable doubt means. And so...
but when I read that hesitate to act language, the instruction that says a reasonable doubt is a doubt that would make one hesitate to act, doesn't that immediately beg the question of hesitate to do what kind of action? I mean, there are actions that you would require a great deal of proof before you would want to take them, and there are actions that you would require less proof, depending upon the nature of the action. So it seems to me that formulation is not particularly clear, is it?
So the instruction regarding, the requested instruction regarding hesitate to act.
Doesn't the requested instruction, it's an extra paragraph of what's already firmly, so actually we've got that on top of.
And that's, I suppose, what I inartfully was trying to get to with in answering Justice McDonald's question is our proposed instruction includes two of the approved formulations and therefore is more likely to enable the jury to actually understand what reasonable doubt means.
Up to Justice Mansfield's question, there is criticism of the hesitate to act language, stating that it's really wrong, that a juror who hesitates in making the decision is a good thing, and that they should be considering the evidence, but merely because they hesitated doesn't mean that the standard of proof hasn't been met. And that was Justice Ginsburg's criticism of the rule. So why is that a better formulation if it's not true and a not accurate statement of law?
For one thing, I don't recall if I believe in the formulation that Justice Ginsburg was commenting on. The Nebraska instruction had included only the hesitate to act language. I don't believe it included, these alternative formulations, for one. And so perhaps it's true that without, the additional, firmly convinced language that is included in the model instruction that was requested, that perhaps it is problematic just to include hesitate to act language. However, when submitted in conjunction with that other language, it is more likely to convey to the jury what is actually meant by the concept of reasonable doubt, which has historically been very difficult for both the courts and for jurors to grasp, and for the courts to explain.
The original, the older version, it talks about that a person is convinced if firmly convinced and not firmly convinced. It gives nice examples of both of those iterations. Doesn't it seem like adding more to it? Where it's a slippery slope. Where would a judge have to draw the line? Wouldn't that happen in a lot of cases? People say, I just want to add more language. I just want to sprinkle more. If there's nothing wrong with the foundational language, I'm having a hard time understanding in this situation. If two are constitutionally sufficient individually, wouldn't it be an abuse of discretion whether or not the judge decided not to include that second paragraph?
And like I said, that's precisely the question that we pose, is what exactly is meant by Alcala and the discretionary component versus a mandatory instruction, whether it's referring to whether the matter being instructed on is itself something that has to be instructed versus a cautionary instruction, like in Lemasters that Alcala had discussed. Or whether it is instead this question of, two equally correct jury instructions that contain different language.
You're not saying that this language has to be added. You're saying just that it could be added. It could amplify it, but it's not wrong not to add it. Is that correct?
Defendant does not contest, the decision in Frey that said that just submission of the firmly convinced language is minimally constitutionally sufficient. Defendant's position is just that upon defendant's timely request for amplification with the hesitate to act language that's included in the current ISBA model instruction,
Your time's almost up. Let's talk about the Campbell case and instruction number 2. The Campbell case is I think, a little bit of an odd duck for me. And I characterize it as an odd duck because it has a lot of language about ABA model instructions, et cetera, assuming that we have a negative view on the instruction that was given, and I just throw that out conceptually, assuming we don't like it, Campbell seems to require a showing of prejudice. And I'd like you to address how you show prejudice in this record.
So what defendant would propose is that the other manner in which Campbell and the preceding case law on that issue in requiring an affirmative showing of prejudice, the other way in which that's all kind of an odd duck, is that even where it's preserved, where the request for, the Campbell procedure has been made, the case law that requires the defendant to affirmatively show prejudice is contrary to what happens in all other jury instruction cases, where preserved instructional error, is instead reviewed to see if it's harmless, and the state's burden is to prove that harmlessness. To the extent that it perpetuates that, and I'm not sure Campbell's quite clear on that post Campbell, right? Because of the fact that Campbell changes the rule in terms of establishing that court should closely follow the ABA procedure. It didn't apply that rule in Campbell, but it prospectively established it. So I'm not sure that we have a case where, in the post-Campbell world, where that particular question has been addressed. But to the extent this court reads Campbell as, continuing that requirement of an actual showing of prejudice by the defendant in the post-Campbell world, defendant would argue that that aspect of it is incorrect.
Do you have a showing of prejudice?
If it is correct, do we have a showing of prejudice? So defendant's position is that, we do, under the facts of this case, for all of the specific reasons that are discussed, in the brief, in addition to the research discussing how, verdict urging instructions, the giving of a supplemental instruction instead of repeating, the one that was already given is coercive, and the court has recognized that it carries a great risk of coercive impact. In this particular case, the verdict was reached just shortly before the end of the day, when the jury would either have had to, tell the court that despite this, further urging, that they weren't able to reach a decision, or.
They got the Allen instruction. They had been deliberating about 7 hours, and didn't they deliberate an additional 4 hours after that before verdict was reached?
Correct. But, defendants' views that whole standard of applying, speculating about what meaning is attached to the differing durations of deliberation is entirely speculative. And in fact, one of the cases that I submitted, the defendant submitted as additional authorities, applies kind of the flip of that, saying that there was so much deliberation here that in fact that supports that this was coercive, and reverses. Okay, yes, and so on both of those grounds, particularly relating to the jury instruction errors as well as the other issues raised in the brief, defendant would respectfully request a new trial. Thank you.
Thank you, Madam Chief Justice, and may it please the court. Ms. Reddy, students, good morning. Louis Sloven on behalf of the state. It's a privilege to be here. I want to start with the standard of review because I think this resolves a lot of the issues that we're having here. For jury instructions under Alcala and the cases that followed, I think there's a two-tier system or two layers to it. The first question is the district court has to determine, at the proposed final instructions, when the defense objects and says, I want this additional instruction, the court has to say, do the instructions that I've already provided, the proposed instructions, already explain the applicable law as should be applied to the facts of this case, already explain it adequately and correctly? That ruling, whether the instructions are already legally adequate, that is reviewed for errors at law under Alcala. But then if the district court says, my instructions already embody and include this concept. Then it's a discretionary determination as between different competing versions of language to explain the same concept that's already present. And that is reviewed for abuse of discretion. This court said that in Tipton, in Plain, in Williams. It's not, I don't think that it requires additional clarification, although I suppose it couldn't hurt. I think it's clear from this court's cases after Alcala that there's these two different questions. For the reasonable doubt instruction here, I think that the defendant correctly concedes that under Frey, the firmly convinced instruction is a correct, full, adequate explanation of the burden of proof beyond a reasonable doubt. I would say that firmly convinced is the best version among there are other possibly correct explanations of the burden of beyond a reasonable doubt. I think hesitate to act does have the problems, Justice Mansfield, Justice McDonald, that you pointed out. I think that firmly convinced is correct, and I'd say the most correct. I wouldn't say it's error to use hesitate to act, but I think that's why district courts have discretion to choose from among different potentially correct versions of the instruction, of explanations of beyond a reasonable doubt, and choose the one that is the clearest. I would also say that I was rereading State versus Tabor, 2011 Court of Appeals, where the court says, we don't have to decide whether Tabor's requested instruction is itself correct as a way to explain beyond a reasonable doubt. We just need to decide if the district court's version was correct, and then if it was an abuse of discretion to give it. And that, I think, illustrates why it's important to reject Ms. Reddy's proposal that the district court should be required to give any correct alternative instruction proposed by the defendant. Because in that situation, suddenly the district court has to tackle the tricky question of, is this, and it might be the stock instruction, it might be a version that the district court has never seen before, that no American court has considered, and has to determine, is this a correct explanation of beyond a reasonable doubt? And a lot is at stake on that. That's a very difficult question to answer when facing a new definition that hasn't been considered before.
Way in favor of the court ultimately deciding on a preferred instruction, given the importance of the instruction, given how frequently the issue is litigated in district courts, and you know, almost in every case, competing instructions are presented to the district court judge on reasonable doubt. So why would we not want to resolve this at least as a supervisory matter and say this is the preferred instruction?
You're correct, Justice McDonald, in that it is preferable for this court to weigh in and bless at least one instruction. I don't think it's problematic if this court blesses multiple different instructions as potentially, or as each correct and each potentially usable. The way that we keep the system, the way that it works and allows district courts to say, don't have to interrupt trial to do a boatload of legal research into determining the correctness of an instruction they've never seen before, to say, here's an instruction that has been blessed by this court, and Frey is a good example of a case that from this court, and the district court correctly referred to it and relied on it. And as long as I use the instruction from Frey, I know I'm giving a correct explanation of beyond a reasonable doubt, and I'm exercising my discretion to say, it doesn't, this version could be correct. It doesn't look to me like a misstatement, but I don't need to resolve the question of its correctness in order to say I already have an instruction that explains this adequately, correctly, fully, and that's the one I'm going to give.
Donald is suggesting is exactly what happened in Campbell, it seems to me. In Campbell, the court expressly approved the ABA approach to Allen charges at substantial length. And A, that didn't happen here. B, there's at least some language in Campbell talking about prejudice. I'm sure you have a position on that. And I want to drill down on that as I did with other counsel, and that is this. How do you show prejudice? I mean, this timing business strikes me as semi-ridiculous. I'll just roll it out. It gives it a patina of objectivity, but gosh, does long deliberation, which way does that cut? Short deliberation, 4 hours, 3 hours, 8 hours, 6 hours. It seems to me that the prejudice prong is almost impossible to meet. So help me out.
Agree, and that's our notice of additional authorities pinpointed a secondary authority that collects a whole bunch of cases about different facts and circumstances that have been used to show and assess prejudice. My favorite is the one where they remove the crossword puzzles from the deliberation room upon a report that a juror was doing crossword puzzles instead of deliberating. But I take your point that the time inquiry, there's no hard and fast rule. It is going to be a little bit of a case-by-case, fact-dependent inquiry. If you deliberate for 8 hours about, half a day's worth of testimony, that's one thing. If you deliberate for 8 hours about a week's worth of testimony, like here, that's very different. And in Wright, the Iowa Court of Appeals considered a state's appeal from a trial court's or a district court's order granting a new trial, finding that the verdict urging instruction that it gave had been coercive, and it found prejudice. And I think that you can look at that opinion and see there's a lot of different facts that you can consider. And another thing that jumps out at me about that opinion is that the usefulness of fact-finding by the district court about the effects of its instructions on deliberations, and how this is another context where district courts have a lot of discretion to assess the feel of the deliberations at that point.
We don't have broad discovery of jury verdicts. I mean, once in a while we have it's kind of an oddball case really when you have crossword puzzles or who knows what. Generally speaking, the jury deliberations, we don't get insight on. So there may be a few cases where we have some external evidence of jury deliberation that kind of reinforces the notion that this was too coercive. But in most cases, we're just not going to have it. I mean, we are going to have the clock. I mean, we are going to have 7 hours before, 3 hours. We're going to have that in every case. But beyond that, we're not going to know what impact this instruction, if we think it's flawed, may have had.
So just one more thing on the time angle. What we're looking for is not a specific amount of time. We're looking for a median or a intermediate range where it's not, we got the instruction, we know what the court wants us to do, let's vote within 20 minutes, and it's not, we've been here for 3 additional weeks and we keep getting, please continue deliberating. That effectively coerces us into that's the Conklin, I think, is the case in Ms. Reddy's notice of additional authorities. But the other things you can consider are the language of the instruction. Now, this one specifically over and over says reach a verdict if possible, if you can do it conscientiously, agreement if possible. And that kind of cautionary language.
Instruction is not all that different from the ABA formulation, is it?
And that's one of the things. Now, Campbell says we recommend that you use the ABA procedure, but Campbell also says what happened in Campbell was not reversible error, that it identifies things about the instruction that was given in Campbell that it didn't like, and those weren't given in Parmer, and they also weren't given here. And so the courts are saying, well, there's a recommendation to use the ABA, to just refer back to the ABA instruction, but also it's not error to give an instruction as long as you don't say the things that have been identified as being erroneous. And that, again, we're talking about district court discretion to respond to the needs presented on a fact-specific basis that this jury seems to have been deliberating for an intermediate amount of time, indicating that they're deadlocked, and maybe they need to hear something other than please continue deliberating, please reread the instructions, something to let them know that the district court hears their statement that they're deadlocked and that it doesn't matter what you say, I'm always going to respond, please continue deliberating. This at least says...
The initial set of instructions?
I think that it has to be a discretionary call as to whether the district court thinks that this is just a jury that hasn't deliberated enough to be able to say that they're deadlocked, enough given in light of the case that the evidence that they're being presented.
And correct me if I'm wrong, of course, I know you will, but I think under the ABA structure, the verdict urging aspect of the somewhat mild ABA instruction has to be given with the initial set of instructions. And then, of course, if there's deadlock, the district court says, well, instruction 16, please reread it, kind of thing.
What I'm saying is that the discretion of the district court to say, in this case, a little supplemental instruction about, I hear you saying that you are deadlocked. Please return to deliberations in a spirit of open-mindedness and listening to each other, not directed at the minority, not inquiring as to the numerical split, not saying this case has to be retried by someone at some point, not mentioning expense, none of that, none of the bits that are coercive. And the ABA model, Campbell says, one of the reasons we like just referring back is because we think the jury might be vulnerable to coercion at that particular point mid-deliberations. Well, if you give it a supplemental instruction that doesn't have any of that coercion, then that's not a problem. Now, I want to mention, because in the Notice of Additional Authorities, the defendant mentions some cases that seem to say, do what Campbell did, and about the same time as Campbell. It was kind of a trend. Seventh Circuit in Sloven seems to say, we recommend you do what the ABA says. But then later, Seventh Circuit in Fouse, F-O-U-S-E, recaps some of its cases saying, you don't need to do exactly the Sloven instruction. If you give something that captures the spirit of Sloven and doesn't have any of the coercive elements that we said were problematic, that's not reversible error. Same thing that we have here. Third Circuit is often cited Fioraventi as the case where they said we just don't like verdict urging instructions, do what the ABA says. But then later in Jackson, 2006, the Third Circuit clarifies that it's not always reversible. It's not reversible if it's not coercive.
The other jury instruction, I think it's number 6 or 7, about the hesitate to act versus firmly convinced. The Eighth Circuit has blessed the hesitate to act. Is that correct? I think that's correct. And our court through Frey has blessed the firmly convinced. So, the pragmatic approach. If you were writing the opinion in this case, what message do we need to send to the court? If both of those in different arguments in different arenas, what this case, I have a feeling, is kind of a common issue that happens. State asks for X, defense asks for Y, and these two are battled out at the district level. What direction is needed by the bench and bar from this court on that particular issue, if both of them are constitutionally sound?
If both of them are constitutionally sound, Your Honor, the direction this court should give is that it is within the trial court's discretion to choose between them or to submit both, because both are correct enough explanations of beyond a reasonable doubt that giving either of them or both is not error. Giving either of them or both, you have an instruction that is fully, adequately, completely explains the applicable law that the jury needs to apply. So you're past that first tier where it would be review for errors at law. And then it's discretionary. It's the trial court saying, and one of the things I like most about Victor is that it says, it's talking about instructions for beyond a reasonable doubt from ages past. And then it says words and phrases can change in meaning over time. And something that was perfectly understandable in ages, previously may ring differently to a modern juror. And I think that's a common thread that flows through both of these challenges. Campbell's a 1980 case, and then more recently, the district court got guidance from Parmer, admittedly unpublished court of appeals, but to a district court, it's relevant guidance. And that's more recent guidance on a permissible supplemental instruction mid-deliberations. McGranahan in this court in 1973 seemed to approve a hesitate to act instruction, although also cautioned district courts not to innovate when it comes to beyond a reasonable doubt. I'm sorry, I see my time's expired. If I could just briefly. Thank you. And then more recently, got guidance from Frey approving a specific formulation of beyond a reasonable doubt. And the common thread is that district courts have to walk a tightrope and craft instructions to withstand review, but also explain adequately, fully to the jurors today in this district the concepts they need to apply. And this court should recognize and reinforce their broad discretion to do so. Thank you.
To approach the podium, I want to ask you the very same question I ended with him. Pragmatically, what should this court do to give direction to the bench and bar if you can assume both of those instructions are constitutionally sound?
Defendant would propose is that the district court should perhaps defer to the preference of the defendant. That's one alternative, approach this court could take. Alternatively, another alternative could be that, we have 3 formulations that are established as correct. And so if either party is requesting the addition, or supplementation with one of those formulations, that request should be granted, whether that's the defendant or the state. Those are, maybe 2 alternatives that this court could do in terms of guidance to the district court.
So that would mean that you would get both the firmly convinced and the hesitate to act instruction?
So if the court's proposed instruction submitted just the firmly convinced and defendant or the state requested addition of the hesitate to act language or vice versa, that could be the guidance that this court provides, that if one of the parties is requesting amplification with one of these approved formulations, because there are 3 that are approved, and that's how I want to touch on that, because I know that the state talked about in McGranahan discussing, cautioning not to innovate. And I certainly recognize that. Defendant's position is not that the defendant's, choice of language always has to be accepted. The issue here is that we have multiple formulations. And McGranahan, in citing the federal case of McDonald, I think, in that decision about, not innovating, talks about how we have multiple approved instructions, and so we don't need to depart from one of those approved instructions. So it's not that, submission of an additional approved formulation is, is discouraged if requested. It's that new innovations, new instructional language that is not, encompassed in these already approved formulations, that is the innovation that, McGranahan and the federal case that it cites caution against.
The risk of confusion increase the more different formulations you add on.
I think the problem is that what the concept we're trying to get to is reasonable doubt, right? And so it's not that firmly convinced is what it means. Rather, it's an explanation of what it means, right? And so, the question of whether hesitate to act means something different than firmly convinced, for example, isn't the question. It's not that we're confusing jurors and they might apply different standards. Rather, these are just different ways of explaining the same concept. And maybe we're more likely to get the jury to actually understand the concept of reasonable doubt by providing these alternative explanations.
Has a paragraph saying reasonable doubt is blah, blah. And then it talks about if after full and fair consideration you are firmly convinced of guilt, you have no reasonable doubt. But after full consideration, you are not firmly convinced, then there is reasonable doubt. When you throw in one more paragraph, and that paragraph keeps talking, it uses the term reasonable doubt again several times. It's the kind of doubt that would make a reasonable person hesitate to act. It also uses the word convincing, which is in the older instruction, of such a convincing character that a reasonable person would not hesitate. Haven't we all of a sudden thrown in a whole bunch of more words, some of them the same as above? Haven't we kind of complicated it instead of simplified it?
I guess I don't think that's true. I mean, I think it's reasonable for different persons or different litigants to understand that differently. And part of it is, like I said, it's not exactly clear how juries,
You've had a hard time, I think, in articulating exactly how does the language you want in there make it better?
I think it's an amplification. I don't think this court, in order to grant
Because
additional explanation.
Negative, or it can't be contrary to the law. So it has to enhance it. How does it enhance it?
It's an additional explanation of what that concept is. Hesitate to act. I mean, hesitate to act is different from the concept of the firmly convinced and the other language that I think that concern about repeating language talks about. It's the hesitate to act phrase that defendant is trying to rely on in arguing that the evidence, created a reasonable doubt, that at the end of deliberations, the jury should still hesitate to act to convict the defendant because, so it explains that there is, that is what reasonable doubt is. Okay. So in light of that, defendant would request relief both on the two jury instruction issues raised as well as the other issues raised in the brief. Thank you.
The case of State versus Davis is hereby submitted. As I stated earlier, we are, for the next case, State versus Kunjan, we're going to have an attorney participating remotely. We will take about a 10-minute recess to allow setup. There may be a lag or buffering for anybody who's live streaming this, but that will be temporary. Thank you. And for the students and everyone who are here, it's a 10-minute break if you need to get up and take a comfort break, and then we'll resume in 10 minutes.